So welcome to my talk. This is, hey kid, don't copy that floppy. Make sure you put your copyright notices on any pictures you steal from the internet. So I got to get something off my chest. I'm pretty damn nervous up here because there's a lot of people in the room. And you know, as the saying goes, there's an elephant in the room. It's something that people probably in here are already aware of. And as the saying goes, if there's an elephant in the room, you should probably introduce it. And you know, it's kind of been not so much of a secret of mine, and I've told my parents, and they're of course disappointed, but they're coping with it now. Some of my close friends know this as well, and I feel, here at Ruby Fusa, it's not a very big conference and stuff. I can kind of exclusively tell you guys this news. I got to make this sort of announcement, get it off my chest before I really go crazy in this talk here. So I am not an attorney. Whew. Oh, that felt good. Okay, all right, cool. Now that we got that out of the way, I want to make sure you really know I'm not an attorney. Actually, my attorney advised you that I read this, and it's kind of insulting to read stuff to you guys, but this, I promise, will be the only thing I read to you. But this talk is provided for informational purposes only to get you thinking about software licensing. Although I, Aaron Kalin, will attempt to give accurate information in this talk, you should consult a professional attorney to verify information given in the following talk. Anything I say in this talk should not be offered as legal information. I am not an attorney. Got that clear? Cool. So right now I feel a bit like Joe Pesci and My Cousin Vinny. If you have not seen this movie, I highly suggest you check it out. Because the premise of the movie, if you haven't seen it, he's called in by his nephews who get in a little bit of legal trouble, and they need someone to help get him out of jail. However, he doesn't have a license to practice law, so he sort of bullshits his way into a courtroom and actually helps them win the case, which is cool. But I feel like him right now, but he's also the best bullshit artist ever, because he can actually make people think that he's an attorney. And again, don't forget that copyright notice. So background in this talk, I saw this slide from a guy named Zach Coleman. He works for GitHub, and he wrote this program called Hopper. They went through and checked out all the currently open source projects in GitHub, kind of mined a bunch of data on them. This slide jumped out at me, more particularly that number. 47.1% of projects don't have a license file. That made me worry a little bit, and that's part of where this talk comes from. So let's talk about software licensing, all right? So I'm going to go over 3 main sections in here. I'm going to give you a very brief history of copyrights, and this is going to be the South Africa edition, because I did have this written for US originally. We'll go over open source licenses, some more popular choices out there, and why you should consider a license. And also let's talk about your rights as a developer, because whether you know it or not, your copyrights are being taken from you, and you should probably be aware of it. So let's start with a very brief history of copyrights. All right, 1866, this awesome document called the Berne Convention for the Protection of Literary and Artistic Works is signed. There are many signing countries. And when they actually sign this, they all are agreeing to recognize each other's copyrights, specifically the copyright law itself. And it also sets a minimum bar for the length of the copyright itself. It's a minimum of 50 years. Some countries add on to it. In my home country, United States, we do lifetime of the author plus 70 years, just in case. The big thing with this document that you need to remember and keep this in mind throughout the rest of the talk is you are automatically granted copyrights on an original work. You don't need to print out your source code. Wouldn't it be hilarious to print out the source code for the Linux kernel if you wanted to copyright it? Yeah. So you don't have to ship it to anyone or anything like that to have your copyright officially recognized. You just have to prove that you were the one who did the original work. You're automatically granted it thanks to the Berne Convention. But there's a fun fact in all of this. South Africa was not officially formed yet when this got signed. I think it didn't happen until 1910 when they officially became a country. So in 1928, they became a signing member of the Berne Convention. So if you are from South Africa and stuff, you are now part of this Berne Convention. And to modernize this copyright law, a new one got passed in 1992 called the Agreement on Trade-Related Aspects of Intellectual Property Rights, called TRIPS for short. You know, programmers aren't the only ones who can come up with some really screwed up acronyms. But what this really does is it gets the rest of the world, just like the Berne Convention, to agree on a minimum standard for copyright. So in case someone steals your stuff, you can run off to another country and say, hey, this is our copyright, we need to enforce this in your country. all of them are kind of agreeing with each other that that should be legal to do. And so, like I said, it's adopted virtually everywhere, including South Africa. There are some states on the northern side of Africa that have not recognized this yet. I think they're still working on adopting it. So it's very similar in terms of like being part of the Berne Convention itself. The laws are very, very similar. They just kind of lay the groundwork. It just sort of updates it to the modern world. So that's that very brief history of copyrights. Let's talk about open source licenses. All right? I'm going to go over 4 popular ones. BSDMIT. They're both roughly the same as far as like their layout and structure. Creative Commons license. This is actually a really nice one. GPL version 3. There's 1, 2, and now 3. And Apache version 2.0, which is actually one of my faves. But before we really get into those, let's talk about some forms of copyrights. So there's copyright licenses, and there's copyright assignment. Those are like 2 very distinct things in copyrights. So copyright license, I see like the C of Max and stuff out here. Did you guys read the 65-page, or now it's more than that, end-user license agreement? It's fun reading, isn't it? Like, you need probably a bottle or 2 of wine, I'm sure. But in that, they're giving you a rental copy of basically the Darwin kernel. That's like their version of the BSD kernel. They're giving you a license to use it. And more specifically, what they're telling you is you cannot modify it. You cannot reverse engineer it. You can't touch it. In fact, if you do, they're probably going to want to talk with you. And then copyright assignment is the sort of opposite of that. You are assigning your copyright to someone else, or at least you're giving them a modifiable version of that license. You're saying, well, I can give you my software. You can do with it what you want as long as you preserve it, or you can put in stipulations like you have to pay me if you're going to use it. So, or specifically, if you want access to modify it, you have to pay me to use it itself. And with those open source licenses, the common thing you will see in them is a warranty clause. And I hope they have a warranty too, because that looks like a very bad accident. So with that warranty clause, all it's really doing is releasing you from liability. Very specifically, it's saying that if an open source piece of software crashes your website and you lose millions of dollars, you can't come after me. If I put that the open source code and stuff out there. So that's all it's really doing, is preventing people from coming after you for damages. So that's a very important clause to read in all of those licenses. There's also something called copyleft, which you'd think is the opposite. So you get copyright, copyleft. But all it really does is it preserves the copyrights on any derivative work. So if I fork a project, if there's a copyleft clause inside of a license, all my work that I create falls under that license. Not all licenses have this in particular, but Creative Commons does, so that's why I'm discussing it now. And another thing that's coming up more recently is patents. Yeah, patents suck. But they're really good if you need to protect your code. But you can patent code. More specifically, you can patent algorithms and systems and stuff like that. Patents are coming up more and more in the software world, and you actually really need to start worrying about them, especially if you're a large company and you have business processes that are codified in code. Generally speaking, you're going to have, you may accidentally contribute something that was part of your copyrighted and patented work into some other open source project, and there are repercussions for that. But like I say, this is a gray area. This has been discussed heavily in the European Union when they almost passed certain laws to make software patents a possibility, and it's back and forth. I'm not going to really weigh in on this because it could be its own talk. But don't feed the patent trolls. I'm putting that in here just because patent trolls are becoming bigger and bigger all over the place, and it's something you should think about when you put up open source code, because if someone comes in and contributes a patented piece of code, you can get screwed pretty badly. Another cool thing you should consider adopting is a contributed license agreement. You typically see this with Apache 2.0 license things. So if I remember correctly, the Puppet and Chef projects out there that are in Ruby both use contributed license agreements. And their entire purpose is to reassign the contributor's copyrights back to the original project. Because believe it or not, when you contribute code to most projects, unless the license explicitly states it, the code that you put in is copyright you. So it's actually your stuff, you wrote it. Unless the actual original license reassigns your copyright, you're actually licensing your work to the original author. So a contributed license agreement does is it kind of levels that playing field for everyone. So I can contribute some code and some other guy takes my code and runs off and makes money with it. It makes sure that all of us are equal partners. So why license? The big reason why is it allows for contributors in your project without violating your copyrights. That very specific. It's really cool that, I try not to pick on GitHub here, but they are the largest open source repository in the world as far as it goes. But when you fork a project and there is no license file in there, or there's no copyright notice that you see in there, when you modify that fork and you send, say, a pull request, it could be very benign. You've officially admitted to violating someone's copyright because you created a derivative work and you've modified it. So, I mean, it does say in the GitHub, user agreement, all that stuff, and you actually go read it. It's really cool to read because it's very well structured. They actually say in there that when you put code up in an open repository, you're allowing people to fork it, but it stops right there. Because anyone can fork it, but if they modify it, they've officially violated your copyright. Just think about that. If you're a business, it is a business decision to license your code in a very specific way. More importantly, you're controlling distribution once it's out there. Once your code is open sourced, you want to make sure that you set some rules to make sure that someone just can't take your core business idea and run off and make even more money than you do and eventually possibly buy you out. That'd be ironic. So let's talk about some of these licenses. I've just been rambling on about the different things that are with them. So let's talk about the BSDMIT license. But I'd rather let David Heimermann Hansen describe this. He's pretty good at it, actually. That sums it up in one slide, I think. And in fact, whenever I see any crap come up about Rails and forking it and stuff, I just think back to this slide because it is true. The only thing that is in that, BSDMIT license is really just, it's enough said, it's only a warranty clause. It only says in there, he doesn't owe you shit. If that Rails framework has a bug in it that crashes your site and you lose millions of dollars, you can't come after David Heinemeier Hansen for that reason. It says very specifically in there that he is not liable for it. The thing I worry about with this particular license is there's no patent clauses. There's nothing in there to protect you from someone sticking patented code into that code base. So I'm wondering if this is ever going to become a problem for Rails in the future. If someone says, hey, I got a cool algorithm that can make active record faster, but what he doesn't know is maybe his company has already patented that and has a registered patent. That could become a problem. So the Creative Commons license. It's really cool because it's got a copyleft option. They call this share alike. So if you actually go through the Creative Commons licensing program, it's really cool. It walks you through so what kind of control do you want in your license? You can just pick and choose oh, I don't want anyone making money off of my stuff, so you can make it non-commercial. You can also make sure that anyone who creates forks of it has to follow your license as well. That's what the copyleft part is. It has very specific clauses to protect the author and contributors in case anything weird goes on. So if the other contributors want to put some code in, if one of them gets a little pissed off and decides to try suing everyone, there is protections in there under the Creative Commons. But there are no patent protections, which makes it a little weird for using it in software. It's still very good. It's mainly geared at media, so pictures, motion picture, and stuff like that. It's very, very good with that stuff. And more specifically, you can set non-commercial usage restrictions, so you can make sure that anyone who runs off with your code just can't go make $1 million for your company out of it. Or at least they have to pay you first, which would be nice. GPL, I'm going to cover version 3. There's 1 and 2, but they're not used very much anymore. V3 was updated to add a few extra things in there. But the nice thing is contributors can set their own license terms, which can get a little weird. So say if I fork a project that's GPL v3. I stick some code in there, but I personally don't want anyone making any money off of it. I can actually put in a notice on that file and say, well, this chunk of code that I put in here, I don't want anyone to be able to profit off of it. You can actually set those terms according to the license. Most companies use this, especially if you're a business, to do dual licensing. Famous one for that is the KDE project. So the whole framework that they use for that is dual licensed. If you're using it for open source, non-commercial purposes, you're free to use it as much as you want. But the moment you want to start making money off of it, you have to pay for a license and go for the actual commercial core of it. So you get some options for it, especially if you're a company that wishes to open source some of your technologies. There are patent protections in there. Very specifically, they say that anyone who puts patented code in there has to grant it to everyone who touches the GPL code, which is pretty cool, but some companies don't like this. They don't want to give away their patents necessarily. There's anti-circumvention protections in here, which is really cool. So say I make a piece of software and it's really good at transcoding video. However, some people decide that they want to use that transcoding to break, I don't know, DVD copy protection and re-encode it and stuff. The GPL would actually protect me because it prevents, so say if someone decides to go misuse your software to break copyrights and things like that, you're not liable for those particular things. It's similar to that warranty clause, but they're actually trying to break away from mainly my country, the United States, where we have some rather heavy-duty laws on copyrights. So the GPL also has many derivative versions. You've probably heard of LGPL, the lesser GPL license, the lesser GNU public license. AGPL, which is great for services. So if you're a service-oriented company, you may want to look at the Affero GPL, as it's called. There's even more that I can't even cover in this talk because there's not enough time. And Apache 2.0 is my favorite in particular because contributors also license their work under Apache 2.0. Contributor license agreements help fill the gap for this particular clause, but anyone who contributes is governed under this license. So if you take in some patches and pull requests and stuff like that, it makes sure that everyone's kind of level playing field, equal partners, and you can't go running off and making money with it without consulting everyone else who's contributed to your code. You kind of limit yourself on that part, but it also kind of makes things more open and equal. But you must preserve copyright notices and derivative works. Very similar with the GPL. You have to keep those notices in there. Very same thing with the MIT license. If you put any copied versions of that code in there, you still have to keep the original author's stuff in there. So say if you go and fork my project, rewrite most of the code, my original copyright notice has to be in there. And it's compatible with GPL, but version 3 only. They actually had to modify parts of the license, and even the GPL had to modify parts of their license to make them work with each other. So Apache 2.0 code and GPL code can live together in the same repository. So say if you have an open source project that's Apache 2.0 licensed, and you see this really badass library that's really cool, and they're GPL v3, you don't necessarily have to bring your project over to that particular license to be compatible. So you guys don't have to fight with each other and all that stuff. You just have to preserve each other's copyright notices. So you'll have to have a lot more stuff in your license file. So hopefully I've given you enough information so you're like, hey, can I have a license? Let's check this out. Before you go licensing and everything, I want you to review the license details before choosing. If you really need help translating the legalese, consult an attorney, like I said at the beginning of the talk. Make sure you include a license file with a capital license and everything in there. That's the traditional thing in open source to do, is to provide that. If you don't have it, throw a notice in your README file, especially when it's on GitHub. It'll be the first thing they see because they display all the README files if they exist. This way, at least people know about your copyrights and what your intent is when you're sharing this code. If your license allows, consider adding a contributor license agreement to the mix. That way you can keep everyone kind of on equal playing ground and make sure that there's no funny business with people contributing and sabotaging your stuff. It hasn't exactly happened yet, but it's very possible. And urge other non-licensed projects to adopt a license so you can contribute legally. Remember I said if you fork and you modify the fork, you're officially violating their copyright. So I think I saw a tweet at one point where someone said, oh yeah, it's an unlicensed project, why don't you just fork it and send a pull request? I would suggest you don't do that. Because, again, you're violating someone's copyright. Just email the author, let them know to check out some cool licenses. You can even suggest one, say like, hey, dude, throw MIT on it, or something like that. That way, and give the reason why. Say like, hey, I really want to give you, a cool pull request. I want to improve your project and stuff, but first we need to set some rules. And I'm pretty sure they'll be more than keen on doing that. If not, just go write your own thing. So that covers the open source licenses section. Hopefully I'm not like totally scaring the crap out of you guys, but if not, I probably will in this section. We're going to talk about your rights as a developer and some of the stuff I've been seeing coming up lately. So if you didn't know, many companies have particular rules about software licensing. In particular, your contract will have rules about how you're supposed to contribute code. Some actually have open source requirements in there. Say if you work for a bank, some of those banks will actually say, we don't trust you working on that open source stuff. We'd rather keep you in the Microsoft or Java universe because you could accidentally contribute one of our patented pieces of software. So they'll actually build it into your contract that says you can't do that. So very specifically, your contract could prevent you from doing that. In fact, it could even prevent you from touching open source in general. So say if you try to bring in an open source project into your code, do any of you here have to have your stuff reviewed by a legal team? Like raise your hand if it's part of your job, if you have to send it off somewhere to have someone look at it first. No one in this room? Wow, maybe I work too much with banking people. So there are companies that have this rule specifically, and even venture capital funded companies. The venture capitalists themselves will add in these clauses to prevent you from getting rid of your valuable intellectual property before, say, your company goes bankrupt, because they want to be able to lock this up to sell it to someone else. So it's worth mentioning in this part here, too, from the United States, we have this very crazy law. I'm going to call it crazy because of all the stuff that it lets you do, but it's called the Digital Millennium Copyright Act. It was passed a number of years ago, somewhat in reaction to the Napster thing. Does anyone remember Napster? Yeah? I think it started us off on the wrong foot in terms of copyright and music. But what it allows you to do is enforce copyright claims in the United States, probably with a crazy degree of effectiveness, mostly because of how you can take someone to court fairly easily over it. But you can wield this power too. So say if you're here in South Africa and all that, and because GitHub is hosted in the United States, they fall under Digital Millennium Copyright Act. So if someone runs off and forks your code, makes a bunch of money with it, or tries to, and you find this out, you can leverage the Digital Millennium Copyright Act and send a notice to GitHub. Just know that they do publish those things. So whenever you do send what they call a takedown notice to say to GitHub, hey, this guy is running off with my code and making money, and I did not give them permission. Now, they will take down the repository and stuff like that for you, so you can do this without the help of an attorney. But again, I do suggest you get an attorney for something like that. They do have documents online on how you can formulate an actual letter to say, please take down this code. You can send this to internet service providers, and for the most part, they will comply, which can also be the problem too, because a lot of them will try to do it to avoid legal hassles. So to get this talk into an even more morbid level, say if all of you guys are going to be hired by me today. I'm going to do this badass startup. I'm going to pay you guys thousands and thousands of dollars, maybe even millions of dollars. But if I ask that, what's your price? Everyone's got a price in their head, I think. But for that price, I get to own any work you create for me, any work you create during non-work hours. In fact, sometimes they'll put in any work you do on company equipment. So if they buy you that nice company laptop, that falls under this category. I also get the rights to name anything you create. So you come up with this really cool gem name. I think that's pretty cool. I want to own it. And as an actual owner and stuff like that, it's built into your contract. They actually call this moral rights. It's usually used for rock stars when they come up with cool song names and the record label wants to have first rights to copyright it. Or even better yet, how about I get to own any previously created works, even when you modify them while on the job. Say if you create a cool library, I want to put it under my company's repository. And most of the developers, they agree to it. And say, yeah, seems legit. Pay me enough money, you get all my creative power. But yeah, this morbid talk is really just to get you thinking about that. But that's your employment contract. You double click on it, it's fine, it looks all cool and peace and harmony until you try to leave. And some companies will actually have an assigned attorney that goes through all of the stuff you've ever done on your laptop to see if there's anything you might be trying to leave with. Sounds really weird and morbid, but that's actually becoming more commonplace, especially in the world of venture capital being injected into our industry. So, sorry to end it on such like a weird, morbid note, but let's do a quick recap, all right, before we just wrap this all up. Review your contract with an attorney to understand your rights if you haven't really read it. If there's some weird legalese in there, clear it up with an attorney you trust, and just have them kind of go over what your rights are before you sign it. Many of them in there will give you a chance to declare your inventions before you join the company. That way you can say, well, I got these gems, I maintain them, blah, 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 these are my copyright. This way you don't accidentally give those up. And if there's anything you're currently working on, you can declare those too long before you release them. Make sure you license your code if you haven't already, because according to that statistic, there's probably a few of you in here that have open source projects that don't have a license file of some kind. So hopefully my, tons of rambling and lots of stuff in this talk have gotten you thinking about putting a license file in there. Because I would hate for you to be on the wrong side of a DMCA notice or something worse. Read your software licenses if you already have them. A lot of the licensing and stuff like that is the level of control you want to have over distribution. And there's some developers out there who are just totally fine with throwing an MIT license on it, and that's okay. It's better to do that if you really want to be part of the open source community than to just not license it, because there can be some problems and consequences with that. And if you see an unlicensed piece of software that you want to contribute to, use that as the reason why they should open source or put an open source license in their software. Say like, hey, I want to contribute, but we need to make sure that this is on legal ground before I do that. All right? So I'm Martini Soft. I didn't introduce myself first. I figured I'd save it for the end. I'd love to hear your feedback on this, because I don't think it's a very widely discussed topic in our community, but I think it's going to start becoming more of one, especially as more and more attorneys get involved with this digital thing. All right? I work for Treehouse. We do lots of online teaching and stuff like that. We show you how to build web apps, mobile apps, and stuff like that. If you're curious, please come find me. I can help you get signed up. But that's about it. Thank you very much to the organizers for inviting me down here. It's my first international trip, and it's been pretty freaking cool so far. So I love it. Thank you. That's me, by the way, if you're curious. We can talk about that, too. Here's some resources you can check out. That first picture you saw, don't copy that floppy. Probably don't want to bog down the wireless, but if you ever get some time, check it out. It's very amazing. That whole thing was a public service announcement about pirating and piracy. So, and if you're curious about getting licensed, this gem up here, License Generator gem, will actually help you license your project and stuff like that. So, Ruby gem that really helps with that stuff. And CLA Hub is brand new that will actually work with GitHub to do sort of like a Travis CI style check on any pull requests to make sure that people sign a contributor license agreement before contributing code to your repository. It'll actually show you like this person has, because they sign in with their GitHub account, so it checks their GitHub account to make sure they have signed a contributor license agreement with your particular project. So that can make that very, very easy if you want to do that. And that's about it. So, thank you.